Thank you very much, Professor Yogesh ji, for giving me this opportunity of my first interaction with the National Law University of Tripura, though online. But thank you so much. I think before I start my views on the topic of transformative constitutionalism, today, as you said, we are celebrating 74th Constitutional Day. uh, I would like to you all to join to pray to those 41 workers which are held up in Uttarakhand in a tunnel, because Constitution guarantees us uh, so many rights, including right to life, dignity, and we pray together that the life of these 41 workers who are stranded inside the tunnel, they are saved uh, at the earliest. With this prayer, now I come to the topic. You have given a wonderful introduction to the topic itself, laid down the foundation for my lecture. But before I dwell on this further, uh, I would like to say that while introducing me, you used a number of adjectives like legal expert or a great teacher, leader of legal education, or a legal scholar, or a leading figure. These, I think, are a misnomer. I am not any one of them. I am only a student of a constitutional law, and I'm learning constitutional law from various sources, including from my student. I know your book on dissenting opinion and the judgment. That was a great reading for me, which you presented me in one of the meetings personally. So I am a student of constitutional law, not a legal expert or a leader of legal education or a legal scholar. But anyhow, be that as it may, thank you so much for giving my introduction. Now, coming to the topic, uh, I'll first of all give certain general statement in addition to what the Honorable Vice Chancellor has stated, Professor Yogesh Pratap Singh ji. Constitution of India is a fundamental law of the land, which we all know. Uh, you have also said and rightly said it is a very living and a dynamic document which keeps on evolving with the time as well as with the circumstances. And above all, to do justice to the topic, we must understand the difference between the constitution, the constitutional law, and the constitutionalism. Of course, many teachers or many students may be knowing it, but there may be among the participants certain fresh student. For them, it is very important to understand. Constitution is a document which is a text given in the Constitution of the various provisions. To that we call the Constitution. The Constitution, when that text is put into application, including the rulings which come from the judiciary, because Article 141 of the Constitution says that whatever the Supreme Court decide, that is binding on all the courts of India within the territory of India. Now, what can be binding? The binding can be only law, and the law emanates, and the law has to be in consonance with the Constitution. And therefore, read with Article 13, the valid law may come even from the Supreme Court. So that becomes the constitutional law, which may not be a part of the text. I give you an example how we appoint the judges of the Supreme Court. It's on the recommendation of the collegium. The word collegium does not exist anywhere in the Constitution, but it is a part of our constitutional law till it is continuing. Similarly, we talk about basic structure theory. The word basic structure is not used anywhere in the Constitution, in the text of the Constitution, if I may say, but we test the validity of every law passed by the legislature, whether the center or the state, on the touchstone of basic structure after 24th of April 1973, which is the date of the decision of the Keshwaranda Bharati. And the third phrase, which or the term which we are concerned today, the constitutionalism. Constitutionalism is very important part of the governance, because it talks about the limits of the powers of the government. The country may have a constitution, it may have a constitutional law, but it may not have a constitutionalism. There is a wide discretion power under the garb of the constitution. That talk about transformative constitutionalism, we have to take into consideration that how the text of the constitution has been used to establish as a constitutional law or the constitutionalism over 74 or 73 years. Now, that is very, very important uh, uh, in the context of evolution of the functioning of the government within the framework of the constitution. So, that is what is the constitutionalism. And one of the golden threads which runs through the entire fabric of the constitution, and which also provides us the yardstick to measure the constitutionalism of a country, is what I call the rule of law. The student of administrative law, in particular, refer to rule of law as the three conceptual interpretation which were given by Dicey in 1885 when he wrote the book Law of the Constitution. But the rule of law is like a constitution, is also not static. The rule of law keeps on growing in its meaning and content from time to time, and a number of other contours they have been added without destroying those three fundamental formulations which were given by Dicey, uh, which one of them was the equality before law and equal protection of laws within the territory of India. The second was uh, the the absence of arbitrary power and a wide discretionary power. We must understand, for the use of a power, many a times it is essential that the power must be coupled with the discretion, but the discretion should be regulated. And when the discretion with the government is regulated by well set of principles, then the constitutionalism comes. But if the discretion is wide and the control mechanism of that discretion is weak, those principles may be there, they may be defined, they may be laid down by a particular structure, but if they are weak in nature, then government has a wide discretion that is violative of the rule of law. And the third one is, of course, the supremacy of the parliament. That was in the context of a British constitution. In our country, we say the supremacy of the constitution. And when we talk about the supremacy of the constitution, we have to start who is supreme under the constitution. And we say that in constitution we start from parliament. Parliament is supreme, but it is sub-supreme to the supremacy of the judiciary, and judiciary is further sub-supreme to the super supremacy of we the people of India, which is the starting point of our constitution. uh, Unfortunately, if we study the position of our country in the or with reference to the rule of law, the situation internationally speaking is not very, very happy, though we claim and we are happy to some extent that we are governed by the rule of law. We have constitutional law, constitutionalism in our country. But the World Justice Project report of 2021 put us 79th out of 139 countries. And if we study the World Justice Project report of 2022, then our position in is 77th across 140 countries, uh, as per this report. Now, this at 77th country, we are not really on the top as we should have been. The first country is Denmark, second is Norway, third is Finland. Sorry. So we find the rule of law is more stronger, and hence the constitutionalism is more stronger in the Scandinavian country as compared to our country. Now, when we talk about transformative constitutionalism, let us see what are the factors on the basis of which the World Justice Project report has measured the position of India on the 77th in 22nd report. The first one, which is the heart and soul of the constitutionalism explanation, is what are the constraints on the government powers. Government, we understand the three different organs which have been explained, their powers have been explained in detail in the text of the Constitution. Now, whether the constraint which the Constitution puts on the government, whether they are totally having no arbitrariness or no wide discretion, or they are having only the permissible discretion. That is the first test. Let us take the recent example. The state of Kerala, state of Tamil Nadu, the state of Punjab, they had to move to the Supreme Court for a reason which is cannot be, or which cannot be justified that it should have existed. The reason is these three states legislature, they passed certain bills, and as per the constitution these bills were sent to the governor for his assent. As per the text of the constitution, the governor has option either to grant the consent, sign the bill so that the bill can become an act or law, or to withhold the consent, then give reasons and communicate, or send the bill back to the reconsideration of the legislature. And if the legislature passes the bill again with or without amendment, the governor is bound to sign. And in certain situation, it could also reserve the bill for the assent of the president. But here, the governor did not follow any of these, governors of these states, they did not follow any of these options. So the constraint became very poor, and ultimately the Supreme Court has to intervene and give direction that dispose of the bill as per the Constitution. So we find here that in functioning, maybe this is a scanty example of three states in India, but this kind of a thing, when it happens, that weakens the rule of law and that weakens the constitutionalism. The second is absence of corruption in a country. Now, corruption, again, it is a very, very difficult to judge. It is just like a fish in the water, and it is very difficult to say whether at a particular point of time fish is drinking water or not drinking. So, similarly, whether a corruption is existing or not, um, I need not to go to the individual examples of different scams or the corruption issues. Particularly, we have a number of examples where the government officials, including the ministers, they have been branded with this allegation of corruption, and many cases with the sitting ministers, they are pending. I need not to elaborate because that may lead me to some political controversy which I do not want to or wish to be land in. But yes, the corruption issue has been against the leaders of all political parties. I think you have different example. I need not to elaborate that. The third one is the open government. Yes, India, we claim the government as an open government, but many a time the government decisions are not in consonance with the tenets of open government. The next point or the parameter on the basis of which the rule of law is measured is fundamental rights and their protection. We are fortunate enough that Part 3 of the Constitution deals with the detailed fundamental right. And to add to further, we are lucky to be the citizens of this country, or we are lucky other persons also who are residing in this country to claim fundamental rights which are not expressly mentioned in the constitution because of the judicial interpretation. So we have a written fundamental right, we have unwritten fundamental right in the constitution. On the one hand, we are facing the AQI of Delhi as a worst in the country. On the other hand, in right to live in healthy environment now interpreted as a fundamental right under Article 21. Even in one article, Article 21, so much interpretation has been given, so many unwritten fundamental rights they have been interpreted by the Supreme Court, and they are as good as the written fundamental right, because I stated earlier under Article 141, whatever the Supreme Court declare, that is binding on all the courts within the territory of India, and hence they are law. Uh, Despite that, there are certain people who are languishing in the jails. There are people who are still victims or sufferer of trafficking in human beings. There are many examples where the fundamental rights are violated. We are lucky how particularly the decade of 70s and 80s, I'll come to that a little later if the time permits, but in the decades of 70s and 80s, there have been a lot of judicial activism, particularly in the two areas, the prison jurisprudence and the labor jurisprudence. Many judgments were delivered by the Supreme Court, and the public interest litigations were considered the order of the day. And the third one was the environmental jurisprudence, which was developed and which became the part of fundamental rights we are claiming. But however, certain people are still suffering. The reason for that is that India is not a small nation. India is a very large nation. 130 crores plus or 140 crores we are touching. We are going to be the most populous nation of the world. There, with this kind of a population, despite the judicial activism, there are bound to be cases, there are bound to be instances where the fundamental rights to the people may not be available at the earliest. And that is one of the reasons that we are suffering. But that affects as the constitutionalism. But I must say here that the recognition of public interest litigation, and over the years, uh, the Supreme Court itself laying down the parameter within which it will entertain the public interest litigation and not publicity interest litigation by certain lawyer, that itself is a part of the transformative constitutionalism. The second is that the liberal interpretation of Article 21 and Article 14 and Article 19 in particular, they are examples of transformative constitutionalism. I'm just so far talking about the judicial interpretation of the constitutional provision, but at the same time, the legislature over the past 73 years, they have passed many laws which have brought transformation in the working and in ensuring the rights of the people in India, and they are the examples of transformative constitutionalism. Uh, Another factor on the basis of which we have to measure the rule of law is the order and security. That is very closely related to the previous factor which I discussed, that is fundamental rights and their protection. Uh, we have a very good system of order and security. If life is threatened, if arbitrary decision is taken, a person can go to the court of law. And the most important provision of fundamental rights, which I was referring to, is that right to enforce fundamental right is itself a fundamental right under Article 32 of the Constitution. Uh, but uh, along with this, merely existing of provision is not sufficient. The another parameter of the rule of law is regulatory enforcement. We have laws. We are implementing them in its true reality. That will judge the rule of law, and that will judge the constitutionalism. It is said that not making a law when it is required is bad, But making a law and not enforcing it when it is required to be enforced is the worst. So there are situations where the legislature has enacted the laws, the judiciary has given the judicial decision, but the implementation is not there. Let me give you a simple example of one of the judgments of the Supreme Court. I think, Nachiketa, you can verify this is judgment was of 1980s. I'm forgetting the name, where they said handcuffing of the people should not be there when they are taken to the court unless it is approved by the
Sunil
magistrate.
Batra, sir. Sunil Batra.
Sunil Batra.
Sunil Batra was on a
और
different. This was a
DK Vasu में भी
Prem Shankar versus Union of India.
Premchand.
प्रेम शंकर, हाँ.
It was Prem Shankar.
Okay.
DK Basu also.
Premchand Shukla. Yeah.
DK Basu also, you can. DK Basu was when the Supreme Court laid down different guidelines that when a person is to be arrested, what are the
Right.
guidelines which be observed. That
Right,
was
right,
DK
sir.
Basu case. Now, the judgment have been delivered. They have become the part of the law, but when it comes to enforceability, still the persons are being handcuffed, and we have series of other cases which after 1980, when Prem Shankar not aware, DK Basu was declared that to issue the guideline that DK Basu's police people, they should be made aware. So we have a weak regulatory and enforcement mechanism. That is why we say we fail in uplifting our position on the index of the rule of law. Then the last one, how much people get civil justice as well as the criminal justice. Of course, justice is the most important aspect in the life of a person. Nothing rankles more in the human mind than the sense of injustice. So everybody wants to have a justice. And the notion of justice is variable from the marriage between the same sexes or LGBT community, and they say they are suffering from injustice. But there are people who are happily married or they want to be divorced and they are struggling in the court for decades. They say we are getting injustice. So the justice is a notion which cannot be defined in within the four walls. It is subjective, it is relative, it depends on the facts and circumstances of each case. Similarly, if we talk about the constitutionalism, if I may say, that is my individual notion, it is not given in the Constitution. I would, as a student of constitutional law, say that if I'm living in a country where there is a true constitutionalism, then there is a true rule of law, and the true rule of law and constitutionalism ultimately should give me happiness. So, my state of affair or the index of the people of the country, that should also be judged with the happiness index, gross happiness index. So as we have in Bhutan, they judge their happiness index. But in happiness index also, what we see, our position is not that strong. According to the World Happiness Report of 2023, India is ranking at the position of 126 out of 137 countries, which is quite low. And what is surprising to me in particular is, you may also surprise, people in Pakistan, in Bangladesh, in Sri Lanka, they are more happier. Their position of their country in happiness index is higher than India. Maybe one of the reason we can give for sense of satisfaction that we are a very populous state, so that is why we are unhappy. No, that should not be there. So, broadly speaking, we have mm, transformation which has undergone. The constitutionalism is still there. we can say in Pakistan there was a time when there was a constitution, but it was ruled by military rulers, so there was no constitutionalism. That is one example we can give of a neighboring state. But now again it has a constitutionalism. So we have to have some study, or we have to find out the reason how through we can have happiness index higher through transformative constitutionalism, because ultimately it is the constitution or the constitutionalism which will provide us the happiness to the people. And I think that is one of the desire of each one of us, to be happy in a happy nation. If I study the working of the Constitution right from 1950, we adopted the Constitution uh, in 1949, and then ultimately in 1950 it came into force, 26th of January. Uh, our working has been into different phases, and the different organs of the state, they have played a different role from time to time. The first phase has been from 1950 to 1967. 1950, when the constitution has just come into operation, and those who were given the task of interpretation of the constitution, my references to the Supreme Court and the High Court judges, most of them, they had education during the British Empire, and they had an influence of British Raj over them. So the interpretation of the constitution was very, very restrictive. And if I can give you the example how the British Empire affected their interpretation, is the fact that in British Empire the concept is still there, that Parliament is supreme, and parliamentary supremacy is recognized theoretically to an extent. I'm saying theoretically to an extent that British Parliament can make anything, only thing it can't make a man a woman and a woman a man. So that is what is said with regard to the British Parliament. Now in India, the Constitution very clearly laid down the structure of Parliament, the function of Parliament, and to some extent, yes, the limitations on the power of Parliament also, because ultimately these are the limitations which will govern the constitutionalism. And what we see is in the first particularly this first phase, 1950 to 1967, the parliamentary supremacy was established by the judiciary. You take the case of Shankari Prasad, or right up to Sajjan Singh in 1965, uh, through various judicial decision, that I cannot explain all the judicial decision at the same time. But yes, Parliament was given that they have the power, they can amend any part of the constitution, including the fundamental rights. So much so, certain amendments were made in this particular phase, particularly the first amendment, where how Article 46 was to be implemented, 15.4 was added. Uh, Champakaram Durarajan case, this was also upheld. And then particularly the change which the parliament brought was introduction of the ninth schedule immediately in the first amendment there, and introduction of new provisions in the part dealing with fundamental rights, that is Article 31A and 31B. So this was a very, very important phase where parliamentary supremacy was established, but restrictive interpretation was given in this A.K. Gopalan case with regard to dealing with personal liberty also. That also is to be kept in mind. This phase also saw the death of Nehru as the first prime minister. We saw Lal Bahadur Shastri taking over as the prime minister, but just only for 1.5 years or so, 19 months. And then came Indira Gandhi and started the second phase from 1967 to 77. Now here, the this phase, the second phase, was having supremacy of the judiciary, in particular, if you see 67 to 77. But we don't find state movement of the judiciary in establishing its supremacy. There was also attempt by the legislature to re-establish legislative as well as the executive supremacy. So in the second phase, we find the transformation in the constitutionalism or constitutional law as well also, that on one hand, the attempt of the judiciary to establish its supremacy, the examples are many. I'll be referring to some of them, starting from Golaknath case, then the bank nationalization case, R.C. Cooper's case, and ultimately in 1973, the Keshwananda Bharati case, uh, and particularly in 74, the true example of constitutionalism. One of the cases I am very fond of in referring to is E.P. Royappa's case, E.P. Royappa versus the state of Tamil Nadu, where arbitrariness as violative of the constitution was considered in specific. Then, particularly when we talk about the legislative supremacy, because the legislature also tried to re-establish its supremacy during this period, the introduction of Article 329A, that election of the Prime Minister cannot be challenged in any court on any ground. That was because to protect Indira Gandhi, and particularly the executive supremacy is also there. The emergency of 1975, which was one of the reasons to demolish the rule of the Congress party. And in the legislative supremacy, one of the most historic attempt which was made by the parliament was the enactment of 42nd Amendment, which is sometimes referred to as a mini constitution, which changed so many provisions of the constitution to re-establish the supremacy of the executive and the legislature. So various attempts were made, and ultimately the result was that in 77, when the elections were held, the Congress lost the election, and the new political party was formed with some of the defected members of the Congress party, the old Congress party, including the Morarji Desai, Charan Singh, etc., who ultimately became the powerful people in the newly born party, the Janata Party. With this, the third phase started from 78 to 1988, where we find, and I referred to earlier also, these 2 decades, particularly, or this decade of 78 to 1988, saw the judicial activism and search for a new political party, because the newly formed Janata Party also could not deliver as it was expected and as they had promised in the election manifesto. The one of the contributions from the legislative side, or the legislature or the parliament, was, and as it was promised in the election manifesto by the Janata Party during 77 election, that if we come to the power, we will undo most of the provisions of the 42nd Amendment, or the changes which the 42nd Amendment has brought into. And they passed 44th Amendment, so which can be called in a lighter vein a third mini constitution. The original constitution, first mini constitution, is the 42nd Amendment, and third mini constitution could be just referred to. It is in a lighter vein. Constitution is only one, and it remains only one. Uh, the 44th Amendment did bring some notable changes. But again, when we talk about transformative constitutionalism, it is very intriguing that even today, the 44th Amendment had come in 1978. Even today, some of the provisions of 44th Amendment Act, which has got the president assent, it is act fully, it is not enforceable. The best example is Article 22, Clause 4 to Clause 7. Now, Clause 4 to Clause 7, they were amended again in 44th Amendment. Though judiciary, by virtue of judicial interpretation, is giving the interpretation which was done by 44th Amendment Act. But legislatively speaking, or executively speaking, uh, the amended clauses have not been brought into force even today. Even in 1983, there was a case where the case was filed in the Supreme Court asking to give the direction to the executive to implement these amended clauses. But the Supreme Court said, sorry, it is the discretion of the executive to decide when to bring into force a particular provision of law or not, and we cannot issue amendments. Now, probably we have amended the constitution so far 106 times, but probably such kind of nuances which are still there, which are very, very important part of a transformative constitutionalism, they have not got the attention of the parliamentarian as well as the executive. One of the most important feature from talking from a transformative constitutionalism is the contribution of the judiciary during this period. And if I may refer to the direct or indirect bringing back that due process clause of the American Constitution while interpreting the phrase procedure established by law in Article 21. That was the major contribution. And not only that, the procedural due process, the three parameters which were laid down by Justice Bhagwati in this case, that every procedure should be just, fair, and reasonable. That is the most important contribution. And henceforth, that is 78 onwards, the every procedure which was prescribed by the legislature, that was judged on the touchstone of these three parameters: justness, fairness, and reasonableness. And of course, the Wednesbury principle was introduced in this. So that is a very, very important part. Then there were judicial supremacy was also established when particularly the 25th Amendment that was questioned or sorry, 42nd Amendment that was questioned in Minerva Mills. I think, Priyanka, there is a good laughter from your side. Somebody, anyhow, I'll continue. The 42nd.
I request you to switch off your microphone. Sorry for the interruption, sir.
No, I can stop it if it is boring so far.
No, not at all.
In 1980, when this 42nd Amendment was questioned, which had given a supremacy to all the directive principle over fundamental rights by amending Article 31C, that was struck down by the majority. Of course, Justice Bhagwati opinion is very, very important. Then this period also saw two tragedies, which was a blow to the constitutional transformation. One was a Blue Star operation and the consequences thereafter. Another was a Bhopal tragedy. Then judgment of Shah Bano case came, which was a transformative constitutionalism, though it was the interpretation of a criminal procedure code, the sections dealing with the maintenance, but how it is applicable to Muslim women and bringing the secularism into that was very, very important. Then the next phase, the fourth phase, was from 89 to 96, in which there was actually a political crisis and search for national leader and judicial might which was there. Because in this period we had a Mandal Commission, then we came in, the Babri Masjid dispute was there in 1992, and we find a number of judicial decision during this period. Even the judge's case also came, the second judge's case, the validity of 10th schedule with regard to defection, that wasn't considered in this, and particularly the certain cases with regard to reservation and the RK Sabharwals, etc., they were decided. So this period, we didn't have a stable leader Congress party ruled, which is a minority party, but it was supported by other people. And then how amendments were made to secure the votes in 1995. 77th Amendment is one example. Uh, See how sometimes the parliament makes a law. Article 16 and never prohibited promotion to the people of a certain category. The legislature, in order to catch the vote banks, said because this Mandal Commission case had said that reservation and promotion to the OBC will not be after 1997. So it did not. The Mandal Commission never talked about prohibition of reservation and promotion to scheduled caste and scheduled tribe. It was only case related to OBC. But the 77th Amendment did that reservation and promotion can be given to the scheduled caste and scheduled tribe. It did not talk about OBC. So when the law is passed, they are not sure what the law is being made. So sometimes the parliamentarians, they are ignorant about the focus and the purpose for which the law is made. This is a good point which can be made as a project for study to the law students. Then the fifth phase was from 96 to 2004, where era of non-governmental government and mushrooming of the regional party, because with the help of the small party, the one example is Akali Dal used to have one or two MPs in the parliament, but they became the minister because they were supporting the ruling party, and on that condition they became the minister. So the role of mushrooming regional party was there, which is a dangerous blow to the functioning of the constitution, in my view. If we want to establish the constitutional supremacy, the constitution does not prohibit the forming of the regional parties, but the real composition of the government ultimately which takes place is that we know. I have given you one example that does not reflect the will of the people. Then the next phase was uh, 2004 to 14, when the United Progressive Alliance was there, Manmohan Singh as the prime minister, number of decisions were taken in this. And ultimately from 2014 on, the NDA is in power, where the most important part, and this is the last phase which I want to, because the time is getting over, I just want to say a few things, that in this phase, the judiciary has taken very, very liberal interpretation. And the true example of the true transformative constitutionalism, Professor Yogesh, the Honorable Vice-Chancellor, did refer to a certain judgment, whether it was a Nalsa judgment, recognizing the third gender as a person and not on the basis of sex, and the interpretation of Honorable Justice Sikri in consonance with Article 15 and 16, read with Article 14. It is a true example of transformative constitutionalism. Naz Foundation, Navtej Singh Jauhar, and now the Supriya Chakrabarti's case, which has been decided with the majority. But sometimes, though, the review petition is to be heard the day after tomorrow. That is what I read in the newspaper, that the review petition, the judges have agreed. But in between, Justice Bhatt has retired. He cannot be in the review petition. So it depends. But if you see the Supriya judgment, though that we cannot apply that formula, but it is very interesting to know. Two judges are on one side, Justice Chief Justice Chandrachud and Justice Sanjay Kishan Kaul. They said yes, they have a right to form the civil union. But on the other hand, we find two separate judgment of Justice Ravindra Bhatt and Justice P.S. Narasimha. So, though mathematical formula, if it is applied, 2 is cancelled by 2. And fifth judge was Hema Kohli, who did not write a separate judgment at all. She said, I agree with Ravindra Bhatt and Narasimha. So the opinion of one who did not write a judgment became the majority. Though this is only for the hypothetical understanding, we do not apply this mathematical equation. If we apply that way, then the basic structure theory is only a one judge theory, not 7:6. because 6 judges were on the dissenting side and the 7 judges were with the majority, Justice Khanna's views. But we don't apply. But this is required that if the judgments, that is the point which I wish to make, if the judgment written by the judge is circulated, is first of all written on time, secondly, circulated well on time, and thirdly, if there is a discussion on the judgment which are circulated by the bench, that would probably bring to some consensus. Uh, Professor Yogesh, your Honorable Vice-Chancellor, has done wonderful research. To my knowledge, is one of the first of its kind in India, who has given the importance to that dissenting opinion, how in how many cases the dissenting opinion was there and it is important. And many a times in subsequent ruling, the dissenting opinion has been resulting into the subsequent judgment as a majority judgment. So if the same thing is discussed, debated, uh, I think either I convince you or you convince me. That should be the attitude. And the dissenting judgment should be there, but they should die in most of the cases before they are delivered. But they should not die with the judge who is writing the dissenting opinion. They should die after discussion among all the judges of the bench in bringing about the consensual decision, and that will bring transformative constitutionalism. Many a time, as I gave you the example, two is cancelled by two or six is cancelled by six. Ultimately, one judge judgment, and in particularly superior case, I said the one who did not write the independent judgment, she might have. The honorable judge might have the same reason, but yes, that can be discussed, that can be debated. So we have a very important issue in hand, that how much dissenting opinion should be reflected too. Now here, one of the judge, Justice Rabinder Bhatt, has retired. He is a part of the majority opinion. And in review, if it is judgment is reversed or it is reviewed, probably again it will have to go to a 7 judges bench or a larger bench. So that wastes the time of the court also, and many a time important judgments they remain. We have today the basic challenge before us is when we talk about transformative constitutionalism, the conflict between the nation and the constitution. Sometime it may be brought. The best example I can give you here, though the time is very short, only a few minutes are left, but I'll still give you the example of JNK and removal of Article 370 from the Constitution. Now, when this was being argued before the Supreme Court, that that Constitution of Jammu and Kashmir as a unitarian lay as a separate union territory and abolishing of Article 370, the Honorable Attorney General of India, I always refer to his opening remarks. His opening remarks in the Supreme Court were a reference to what Abraham Lincoln had said long back. Abraham Lincoln said that to save the nation, one has to sometimes sacrifice the Constitution, but not the vice versa. Now, it is a very bold statement, but Constitution survives if the nation survives. If a nation dies, the Constitution does not survive. If Constitution survive and the nation survive, the citizens and the people of the nation, they survive. If they survive, there is every possibility of the constitutionalism, of the transformation through the constitutional means. With these words, I would like to put my lecture to rest. Thank you so